Welcome back to the Deep Dive, where we take your most essential sources and unearth the critical insights, making complex topics clear, concise, and even, dare I say, captivating. Today we're embarking on a deep dive that's absolutely vital for anyone navigating the legal landscape, especially, those preparing for one of the most rigorous challenges in their careers, the bar exam.
Indeed. Today's mission is really to unlock the intricacies of the federal rules of evidence.
Okay.
Our sources for this deep dive are meticulously structured review materials designed to distill these vast legal principles into actionable knowledge.
Right.
We want to provide such a thorough and comprehensive explanation that, well, you could essentially use this deep dive to craft a high-scoring essay on a bar exam. We're going beyond just memorization. We're aiming for true comprehension.
Think of this as your essential roadmap, basically, to understanding how evidence works in a courtroom, what gets in, what stays out, and, importantly, why. We'll be breaking down the fundamental rules, the common pitfalls, those nuanced distinctions, ensuring you grasp not just what the rules are, but why they exist and how they apply in real-world scenarios.
Exactly.
We want to equip you with the insights needed to not just pass, but to truly understand the logic behind these rules. To give you a concrete framework, let's imagine we're working on a case involving State v. Alex, where Alex is accused of assault. We'll kind of look at how each of these rules might play out in that courtroom.
Good idea. Okay, let's unpack this.
We're kicking things off with the very foundation, how evidence is presented and the basic rules that govern it. And that starts with a crucial first question. When do the federal rules of evidence even apply?
Right. And what's fascinating here is that the federal rules of evidence, the FRE, they don't apply universally. They govern most proceedings, sure, but there are crucial exceptions you absolutely need to be aware of. The general rule is pretty straightforward. The FRE applies to all proceedings in federal court. However, there are significant areas where they explicitly do not apply. Understanding these is key to spotting potential issues in, say, a bar exam fact pattern.
So it's not a blanket rule, then. Where do we see these carve-outs?
Well, we see specific carve-outs for particular stages of the legal process. Think of it this way. The FRE tend not to apply where the judge isn't making, a final determination of guilt or innocence.
No.
But rather where they're making procedural decisions or it's investigative steps or maybe post-conviction matters where, frankly, a broader range of information is needed.
Can you give us some examples of those specific stages?
Absolutely. First, the FRE do not apply to a judge's determination of preliminary questions of fact. This is foundational.
Right.
A judge needs flexibility to decide these fundamental gateway issues like, is this piece of evidence admissible? Does a privilege, say, attorney-client privilege, exist? Is this witness qualified as an expert? Applying the full evidentiary rules during these preliminary determinations would just create this cumbersome and honestly illogical loop.
So the judge isn't bound by the strict rules when making those initial crucial decisions about the evidence itself. It ensures they can get the information they need to make the right call on what the jury ultimately hears.
Precisely. Second, the FRE do not apply to grand jury proceedings. Grand juries are investigative bodies. They're not adjudicative trials. Their purpose is to determine if there's probable cause to issue an indictment, not guilt or innocence. So the rules of evidence are much more relaxed there to help the investigation along.
And then there's that critical list of specific criminal proceedings where the FRE don't apply. You mentioned this is important for, bar prep.
Indeed. This list is carved out for very specific stages in the criminal justice process. First, the issuance of search or arrest warrants or criminal summons. A judge needs to make a swift probable cause determination, usually based on an affidavit, often without a full adversarial hearing. Full FRE would just hinder this.
Makes sense.
Extradition or rendition hearings. These are about transferring people, not trying them. Consideration of bail or other release. This decision focuses on flight risk or danger, not guilt.
Right.
Preliminary examinations in criminal cases. Again, primarily about probable cause. Preliminary factual decisions. Any other factual decisions a judge makes before trial that aren't about the ultimate guilt. Sentencing hearings. At sentencing, the judge considers a much broader range of information, defendant's background, crime's impact, not just FRE admissible evidence used to prove guilt.
Okay.
And finally, granting or revoking probation or supervised release. These are also post-conviction matters, focusing on whether conditions were followed, not proving the initial crime.
So the insight here is that the FRE are fundamentally rules for trials for determining guilt or innocence or civil liability. For these other procedural or administrative stages, the court prioritizes efficiency and, well, a broader information gathering scope. Okay, moving on. Let's talk about the roles of the judge and jury. You mentioned the judge makes preliminary decisions, but how does that divide play out in trial?
This distinction is absolutely fundamental. The judge and jury have distinct, non-overlapping roles when it comes to evidence. The judge's role is that of a gatekeeper.
The gatekeeper.
Their responsibility is to decide those preliminary questions regarding the admissibility of evidence. Does it get in at all? They also determine if a privilege exists, like we mentioned, attorney-client, and whether a person is qualified to be a witness, like an expert. Their job is basically to screen out unreliable or improper information before it ever reaches the fact finder.
So the judge acts as this critical filter, making sure the jury only gets information that meets the legal standard for reliability and fairness. It prevents, like, informational chaos.
Precisely. In contrast, once the evidence is admitted, the jury's role shifts. They are the trier of fact. Their job is to determine the weight and credibility of that evidence. They decide how much to believe something, not if it can be heard. So, if a witness testifies in Alex's trial, the judge determines if they can testify and if their testimony is generally admissible, but the jury decides if they believe that witness, how much weight to give their statements, and ultimately what facts are proven by it.
This division of labor is really about protecting the integrity of the trial process, isn't it? The judge screens, the jury weighs. It's a fundamental check and balance.
Absolutely. It underpins the adversarial system.
Okay, so what happens if a lawyer disagrees with the judge's ruling on evidence? You can't just hope the appeals court figures it out later, right?
Yeah, definitely not. If a judge makes an evidentiary ruling you disagree with, you can't just let it slide. There's a specific process to preserve your challenge, and getting this right is absolutely critical for any potential appeal.
Okay.
One concept here is limited admissibility. Evidence might be admissible for one purpose, but not another.
Right. Like showing Alex's state of mind, but not proving the truth of what he said.
Exactly. In such cases, the court has a duty. It must restrict the evidence to its proper scope and instruct the jury accordingly. That's called a limiting instruction.
Mm-hmm.
If the judge fails to do that, it can lead to reversal on appeal because the jury might misuse the evidence.
So the judge has to basically put a legal fence around the evidence, telling the jury, you can consider this for X, but absolutely not for Y.
Precisely. Another related concept is the rule of completeness. This rule says that when one party introduces only part of a statement or record, the adverse party can compel them to introduce the omitted portions needed to clarify or explain the admitted part. It prevents misleading impressions.
So it protects against cherry-picking evidence, ensures the jury gets the full picture, the context.
Exactly. It's about intellectual honesty. Now, for an appellate court to actually reverse based on an evidentiary ruling, there are strict requirements. The ruling must affect a party's substantial right.
Meaning it wasn't just a minor technical error, it actually mattered to the outcome.
Right. It has to be significant. And, crucially, the trial judge must have been properly notified of the error. This is where attorneys really need to be on their toes.
So you can't just silently object in your head and then complain about it on appeal.
Not at all. If evidence was admitted improperly, you have to make a timely objection on the record, stating the specific grounds. Objection, hearsay. Objection, relevance, not just objection.
Okay.
If evidence was excluded improperly, you must make an offer of proof.
Offer of proof. What's that exactly?
It means explaining to the judge, outside the jury's hearing, what the excluded evidence would have shown and why it was relevant and admissible. This does two things. It gives the trial judge a chance to correct the error right then and there, and it creates a record for the appellate court so they know what was lost. Without it, the appeal is likely dead on arrival for that issue.
This really highlights the active role attorneys must play during trial. You have to flag the error properly for the judge.
Absolutely. Now, there is a rare exception, the plain error rule. An error that is so obvious to a reviewing court and affects a substantial right can be grounds for reversal even without a challenge at trial. But this is reserved for truly egregious, fundamental errors. You should never rely on this. Always object, always make your offer of proof.
Got it. Plain error is the last resort, not the strategy.
Okay, next concept, judicial notice.
Right. This is where the court just accepts a fact as true without needing proof.
Essentially, yes, it saves time and resources. But it's not for just any fact. We're talking about an adjudicative fact, a fact typically decided by the jury. For a court to take judicial notice, that fact must not be subject to reasonable dispute.
And what makes a fact not subject to reasonable dispute? What's the standard?
There are two main ways. First, the fact is generally known in the community. Things everyone knows, like, Boston is in Massachusetts, or that gravity exists.
Obvious stuff.
Right. Second, the fact can be accurately and readily determinable from reliable sources. Think facts you can look up in an indisputable source, scientific principles, historical dates from accepted records, maybe government statistics, like the precise time of sunrise on a specific day from the Naval Observatory.
So facts that are either universally known or
Yeah.
easily provable beyond any doubt.
Exactly. Now, the effect of judicial notice is different in civil versus criminal cases. This is a key distinction.
Okay.
In civil cases, if a court takes judicial notice of a fact, the jury must accept that fact as conclusive. They're bound by it, period.
Right.
In criminal cases, however, the jury may accept the fact as conclusive, but they are not required to.
Oh, interesting. Why the difference?
It's a crucial protection for criminal defendants. It reflects the higher burden of proof beyond a reasonable doubt and the defendant's Sixth Amendment right to have a jury decide every element of the crime. So even if the judge takes judicial notice that, say, the alleged assault in Alex's case happened in Chicago, the jury could theoretically reject that fact, though it's unlikely.
So judicial notice isn't just about efficiency. It's the court's stamp of indisputability. In civil cases, it's binding. In criminal, it respects the jury's role and the defendant's rights. It's a tool, but one used carefully.
Precisely.
Okay, with those foundational rules set, let's get into the actual flow of the trial. Once we know what evidence can come in, how does the presentation actually unfold? Thinking about Alex's trial again.
Right. The flow is generally predictable following a standard order, but the court retains significant control. Typically, the plaintiff in a civil case or the prosecution in Alex's criminal case presents their case first.
Their case in chief.
Exactly. This is where they introduce their evidence, call their witnesses, try to establish all the elements of the claim or crime. After the prosecution rests their case, then the defendant, Alex's team, presents its case. They introduce their evidence, call their witnesses to rebut the prosecution or establish defenses.
And the court oversees all this.
Yes, the court has broad discretion to control the order of witnesses, the mode of questioning, the overall presentation. They manage time, ensure fairness, prevent unnecessary repetition or confusion. Judicial control is key to an orderly trial.
Can the judge actually ask questions?
They can. The judge isn't just a passive referee. They can question witnesses and even call a witness on their own initiative if they feel something crucial is being missed or needs clarification.
Wow. Okay, so the judge can jump in if needed.
It's relatively rare, but yes. And if the court does question or call a witness, all parties then have the right to cross-examine that witness. That maintains fairness.
Right.
A critical procedural point here. Any objections to the court's questioning or calling of a witness must be made outside the hearing of the jury.
Why outside their hearing?
That prevent the jury from being prejudiced. You don't want them to think, oh, the judge doesn't like this witness, or be influenced by the judge's intervention or the lawyer's arguments about it.
Okay, that makes sense. Let's talk about examining the witnesses themselves. There are strict rules about the questioning, right?
Highly regulated, yes. To ensure fairness and clarity, let's look at the scope. During direct examination, when you question your own witness, you can generally ask about any relevant matter. The goal is to elicit testimony supporting your case. So the prosecutor directly examines the victim in Alex's trial to get their account.
And then comes cross-examination, which is usually where the fireworks happen.
Often, yes. Cross-examination is generally limited to the scope of the direct examination, meaning you can only ask about topics brought up during direct and matters related to the witness's credibility.
So you can't just bring up totally new stuff, usually.
Not usually, though the court may broaden the scope if it sees a good reason. The main purpose is to test the truthfulness and accuracy of the direct testimony.
Okay.
After cross, there's redirect examination. This is limited to significant new matters raised on cross. It's the chance for the original examiner to clarify things or repair damage done on cross. Again, the court may broaden the scope.
And then recross.
Then potentially recross examination, limited to significant new matters raised on redirect. It continues the back and forth, but keeps narrowing the focus.
It's like building layers of argument, each refining the last.
A good way to put it. Now, what if a witness gives an improper answer? Counsel should move to strike it, ask the court to remove it from the record, and tell the jury to disregard it.
Okay.
But here's a nuance. Only the examining counsel, the one who asked the question, can move to strike an unresponsive answer.
Why only them?
Because they ask the question, they know if the answer is outside the scope or just rambling. If the answer is responsive but objectionable for other reasons, like hearsay, then any party can move to strike.
Got it. Now, the form of the questions themselves, this is where lawyers can really get into trouble, right?
Yeah.
Leading questions, for instance.
Absolutely. The form is critical. Let's start with leading questions. These are questions that suggest the answer. You saw Alex hit the victim, didn't you? Instead of, what did you see?
So the lawyer is basically putting words in the witness's mouth.
That's the concern. On direct examination, leading questions are generally not permitted. You shouldn't coach your own witness. But there are important exceptions.
Okay, like when?
You can use leading questions if the witness is hostile, uncooperative, or biased against your client, even if you called them. Also, if leading questions are needed to develop testimony, think of a child witness or someone with communication difficulties.
Okay.
And if the witness simply struggles with communication, the court allows flexibility there.
But on cross-examination, it's fair game.
On cross-examination, leading questions are permitted and unrestricted. It's a key tool for testing credibility, challenging testimony, probing the witness's account.
So direct is generally non-leading, cross is generally leading.
That's the basic rule. Now, besides leading questions, there are other improper question forms that are generally prohibited because they don't properly elicit facts.
Like what?
Argumentative questions. These are just arguments disguised as questions. Isn't it obvious you're lying? That's for closing, not examining.
Right.
Questions that assume facts, not an evidence. The classic, when did you stop beating your wife? Assumes he beat his wife.
A loaded question.
Totally. Questions that call for a conclusion or opinion from a lay witness who isn't qualified. Do you think Alex intended to cause harm? That's usually for the jury. Compound questions, asking two things at once. Did you go to the store and then the park? Confusing.
Yeah.
Questions that lack foundation, asking about a document before you've shown it's authentic, for example. And finally, repetitive questions. Asked and answered wastes time.
Unless
you're repeating a question from direct on cross or redirect to clarify confusion, that's a legitimate purpose.
these rules really seem designed to get to the facts efficiently and fairly. Keep the lawyers arguing in arguments, not during testimony.
That's the goal.
What about keeping witnesses separate? Sequestration.
Yes, Rule 615, the exclusion of witnesses,
Yeah.
often called sequestration. It's crucial for preventing witnesses from tailoring their testimony based on what others say. The general rule is the court must exclude witnesses from the courtroom upon a party's request. The court can also do it on its own initiative. The goal is simple: prevent them from hearing other testimony.
So, in Alex's trial, the witnesses to the assault would likely wait outside.
Typically, yes. But there are specific exceptions, witnesses who cannot be excluded.
Okay, who are they?
First, a party who is a natural person. Alex, the defendant, has a right to be present throughout his trial. Same for a plaintiff or defendant in a civil case.
Makes sense, it's their case.
Second, a designated representative of a party that is not a natural person, like a corporate officer for a company involved in the suit. Third, persons whose presence is essential to a party's presentation of its case. This often applies to expert witnesses who might need to hear the factual testimony to form their opinions.
Ah, like a forensic expert needing to hear crime scene details.
Precisely. And fourth, persons whose presence is permitted by statute. Some jurisdictions have victims' rights statutes that allow a victim to be present, even if they will testify.
So that's why you often see witnesses waiting outside the courtroom. It's about preserving the integrity of their individual recollections.
Exactly. Preventing contamination, essentially.
All right, let's shift gears slightly to the core of proving facts. Burdens and presumptions. These determine who has to prove what and how strongly.
Foundational concepts, absolutely. The burden of proof actually comprises two distinct burdens. First is the burden of production, sometimes called the burden of going forward.
Okay.
The party with this burden must produce legally sufficient evidence for each element of their claim or defense. Enough evidence that a reasonable jury could find the facts are proven. This creates a prima facie case.
So in Alex's trial, the prosecution has to produce some evidence for every element of assault that he acted, caused harm, had intent, etc.
Exactly. If they fail on even one element, if they don't meet that initial burden of production, Alex could move for a judgment of acquittal, and the case might be dismissed before the defense even presents its evidence.
So if you don't meet the burden of production, you might not even get to the jury. It's the minimum entry fee.
That's a good way to put it. The second burden is the burden of persuasion. This is the burden to actually convince the fact finder jury or judge to believe your proposition of fact. This burden never shifts. It stays with the party who brought the claim or asserted the defense.
Okay, so the prosecution always has the burden to persuade the jury Alex is guilty.
Correct. What does differ is the level of persuasion required, the standard of proof.
Right. How convincing do you have to be?
Exactly. The lowest standard, used in most civil cases, is preponderance of the evidence. More likely than not, over 50% probability. Just tip the scale slightly. Then there's clear and convincing evidence. A higher standard, used in certain civil cases like fraud or maybe terminating parental rights, it's more than preponderance, less than the criminal standard.
And the highest standard is for criminal cases, like Alex's.
Yes, beyond a reasonable doubt, the highest standard. No reasonable doubt as to guilt. This reflects the seriousness of criminal penalties and the presumption of innocence. The prosecution must meet this high bar for every element of the assault charge against Alex.
Now, presumptions. You said these can shift the burden temporarily.
They can affect the burden of production. Let's distinguish two types. First, conclusive or irrebuttable presumptions. These, once established, cannot be challenged. The fact is treated as fixed, like the old common law rule that a child under 7 couldn't commit a felony. They're pretty rare now.
So once established, it's just accepted, no argument.
Right. Much more common is the rebuttable presumption. Once a party produces enough evidence to establish this presumption, the burden of production, again, not persuasion, shifts to the opposing party.
Okay.
The opposing party then has to come forward with some evidence to counter the presumed fact.
Yeah.
If they offer sufficient counterproof, the presumption disappears. It bursts the bubble, as the phrase goes.
Bursting the bubble, I like that. So if the bubble bursts, what happens?
The presumption is gone. The burden of production reverts to the original party. The jury just decides the fact based on all the evidence, without the presumption helping anyone. Think of the presumption that a properly mailed letter was received. Party A proves mailing. Party B now has the burden to produce some evidence they didn't receive it. If they do, maybe testimony about mail problems, the presumption busts. The jury then weighs all the evidence to decide if the letter was actually received.
So it's a procedural device to shift the initial need to produce evidence, but it doesn't decide the ultimate issue if challenged.
Exactly. Another important one is the presumption of destroyed evidence, or spoliation. Generally, intentional destruction of relevant evidence raises a rebuttable presumption that the destroyed evidence was unfavorable to the destroying party.
To discourage people from destroying evidence they don't like.
Precisely. But for this presumption to arise, you usually need to show 3 things. The destruction was intentional, the evidence was relevant, and the party claiming harm acted with due diligence regarding the evidence.
So if Alex intentionally deleted relevant texts about the assault, the jury won't be allowed to presume those texts were bad for his case. It's a powerful incentive to preserve evidence.
It certainly is.
Okay, relevance. This feels like the absolute starting point. Before anything else, evidence has to be relevant, right? The first hurdle.
Absolutely. Rule 401. The golden rule, really, is in Rule 402. All relevant evidence is admissible unless some other rule, law, or constitutional provision excludes it. The default is admissibility, if it's relevant.
So what is relevant evidence, legally speaking?
It's a 2-part definition. Evidence is relevant if it is both probative and material.
Okay, break those down. Probative.
Probative means the evidence has any tendency to make a fact more or less probable than it would be without the evidence. It just has to nudge the probability needle, even slightly. It needs some logical connection. For Alex's case, maybe a witness saw someone fleeing the scene who vaguely matched Alex's description. That's probative, even if not conclusive.
Shed some light, however small, and material.
Material means the evidence concerns a fact that is of consequence in determining the action. Does this fact actually matter to the legal issues in the case? In Alex's assault trial, his identity is of consequence, so the vague description is material. But maybe the color of the socks Alex wore that day? Probably not material, unless it was part of the description.
So it's the 2-part test. Does it matter to the case, materiality, and does it help prove or disprove something about what matters? Probativeness. Both have to be yes.
Correct. Both prongs must be met.
But even if evidence is relevant, it can still be excluded, right?
Yep.
Under Rule 403.
Yes, absolutely. Rule 403 is the big balancing test. While relevant evidence is generally admissible, the court may exclude it if its probative value is substantially outweighed by certain dangers.
Substantially out, that's the key phrase, isn't it? It's a high bar for exclusion.
It is. The rule favors admissibility. The danger has to substantially outweigh the probative value, not just slightly outweigh it.
So what are those dangers?
The main one is unfair prejudice. Evidence that appeals more to the jury's emotions, biases, or sense of horror than to their rational judgment. Gruesome photos, maybe, if less graphic ones would suffice to show injury.
So evidence that might make the jury decide based on emotion, not logic?
Exactly. Other dangers include confusing the issue, sidetracking the jury, misleading the jury, making something seem more important than it is, and practical concerns.